All right, without further ado, our keynote speaker for today. I'm very excited. This person has been on my wish list for quite a while, whether she knows it or not. Chelsea McNeill is a 2005 graduate from Coastal Carolina University and a 2010 graduate from Charleston School of Law. She started her career working in addiction centers, a clinical addictions counselor, working both alcohol and drug safety action program at the Charleston Center, and the Persons Incarcerated Entering Recovery program at Charleston County Detention Center. She then decided to go to law school because she had a lot of free time doing all that, with the goal of becoming a public defender. That is a goal, not to make a ton of money, but to be a public defender. That says something. That's right. So buy her a drink. She can't afford it. She's a public defender, if you see her out and about. She started her career at the Charleston County Public Defender's Office. She moved to Lawrence County, started working there as an assistant public defender. Then she became the chief public defender at the Lawrence office. Then in 2020, she was elected as the 8th Judicial Circuit Public Defender, which is her current position. She runs 4 counties with the 8th Judicial Circuit. That includes Greenwood, Lawrence, Newberry, and Abbeville. Since moving to Greenwood, she's done more than just her work as public defender. She's a Rotarian for the Emerald City Rotary Club. She's vice chairperson for the board of directors for the Greenwood County Humane Society. Who's a fan of the Humane Society? That's right. She's very passionate about indigent defense, issues around mental health, addiction, gun violence, poverty, defending children charged with crimes, human rights in general, and she's also going to talk about bond reform today. Without further ado, Chelsea McNeill.
Thank you, everybody. I'm really honored to have been asked to speak here, and to be quite, can everybody hear me okay? Okay. And to be quite frank with you, I have also been wanting to attend these Democrat meetings. I am a diehard liberal Democrat, and I'm not from South Carolina originally. I'm from Atlanta, then I moved to New Mexico, then I moved to New Jersey, then I moved to California, and then I came to South Carolina for undergrad and law school. And so I've been here since 2001, and I just love South Carolina. My mom is from Charleston, my brother lives there, so I have deep ties and passion for South Carolina issues. Admittedly, I grew up around cities, and so I had actually never heard of Greenwood in my life before I moved here. But I'm really glad to be here. A lot of people, there was 9 other people that ran against me for the Circuit Public Defender position, and for those of you who don't know about that position, it is the equivalent position for the popularly elected solicitor for us, which is David Stumbo. So I am his counterpart, which is not fun many times. So today I want to talk a little bit about bond reform. How many of you, first of all, are familiar with the judicial system of our government? Okay, I'm glad to see that. How many of you in the crowd are lawyers today? Just rock-wise, is that the only one? Okay. Well, when I ran, everybody I had a big support system. I made a good reputation trying really hard cases and winning a lot of cases across South Carolina, and so I had a big group of support that encouraged me to run for office, going back to our previous speaker. And that was difficult. I run in a white man's world in criminal defense specifically, so I understand being prejudiced against. I might have the right color skin, but I certainly do not have the right genitalia in my field. And so that has been a challenge for me, and this job has been difficult for me to, my goal is to build the strongest public defender office in our community in the state of South Carolina, despite being extremely underfunded and in a rural county where we don't have things like public transportation, which is something that I wish that we did have, because I also feel like that would turn out more voters in this community, because we have so many people who live in rural areas, especially in the Black community, who don't have transportation to get to the voting polls, and I think that that should be talked about more often. So today I want to talk about bail and recognizance bonds. So what we have going on here is, and this is all legal jargon, don't worry about it, I'm going to explain it in lay terms, but Section 1715.10 of the criminal procedure statutes is where you will find bail statute talked about. And that says persons charged with non-capital offenses may be released on his own recognizance, his or her, conditions of release, bond hearing for burglary charges. So, a person charged with a non-capital offense triable in either magistrate, municipal, county, or circuit court shall, at his appearance before any such courts, be ordered released pending trial on his own recognizance, meaning a personal recognizance bond where you do not have to go through a company that's there to make money and capitalize on people getting in trouble with the criminal justice system through a bail bondsman. Is there a bail bondsman out in the audience today? Okay, good. All right, because I don't really think very highly of that business. So they should be released on their own recognizance without surety and an amount specified by the court. Usually it's like 1,000 PR bond or 5,000 PR bond. When I say PR, I mean personal recognizance. Unless the court determines in its discretion, so we have automatically you should be released on your own recognizance as soon as you go in front of a judge after an arrest, unless the court determines in its discretion, so we have a lot of judicial discretion here, that such a release will not reasonably assure the appearance of the person as required, meaning to their court date, or unreasonable danger to the community, or an individual will result if such a determination is made by the court. It may impose any one or more of the following conditions of release. And I'm not going to go through all of those, but what I will say is this. When somebody is charged with a criminal offense and they have to, if they're charged with certain offenses and they go to the magistrate or city judge to be arraigned on their charges, and the judge is supposed to set bail, that magistrate judge, who may not even be a lawyer, and unfortunately, I don't know if any of you have been following what Billy Garrett, who was a previous Democrat apparently, has done to our magistrate courts. What he has done is disgusting in my mind. I personally feel that a magistrate who is not a lawyer, I feel that that is the unauthorized practice of law in this state. I also feel that when a person is tried in magistrate court, because in Greenwood County, Lawrence County did have a city prosecutor, but not a county prosecutor, and when a person is charged with something like a DUI, for example, they are prosecuted by the arresting officer in that case. There is not a prosecutor with a law degree. So we have officers whose requirement, and I'm not trying to disparage officers, there's many good ones out there, but unfortunately in my line of work, I also know how vile a lot of officers are in their treatment of the citizens that they are supposedly protecting. And these officers oftentimes are required, especially in this area, only to have a high school diploma. And personally, I feel like a lot of officers, grew up in the community that they serve, or they serve as, a next door community. And they're oftentimes, in my opinion, acting like bullies with a badge and a gun and a terrible haircut. And again, them prosecuting these individuals in magistrate court, in city courts, that is also the unauthorized practice of law. And I cannot stand magistrate court, so I don't practice down there. At this point in my career, the only cases that I take on are if you're charged with murder in one of my 4 counties, I'm automatically your attorney. If you're charged with rape, I'm automatically your attorney. If you are facing the death penalty, which since my time, I moved to the 8th Circuit in Lawrence in September of 2012, I have had 2 death penalty cases that David Stembo has proceeded. I think that he is in a race with some other prosecutors on who can kill somebody first, unfortunately. And I am very much against state-sanctioned murder. I think it is absolutely ridiculous. And what I really don't understand is Republicans often talk about shrinking the government, making them less powerful. Get out of my business, get out of my life, get out of my bedroom. Yet at the same time, these same Republicans are voting for the government, the judicial system, to have the ultimate authority in forcing women to have children, now at a 6-week ban, after Kay Hearn was on the Supreme Court and it was struck down as unconstitutional, and now our state is the only state in this country that has no female on its Supreme Court, and that is shameful. And because Kay Hearn, who I love and really respect, she's an amazing woman and she's made amazing case law, she's not on there now, and now we have another man, and so now the Republicans are trying to push this 6-week bill again. And I have to tell you, a lot of women don't even know they're pregnant at 6 weeks. So this is a huge issue. Sorry, I am preaching, Pastor. So the point is, we have a huge flaw in our bonding system. When deciding to set bond, trying to keep track of my time here. When deciding whether to set bond, a judge is going to consider 3 things. One is, are you a flight risk, okay? So, if a person's criminal record is considered, so if they have things on their record like failure to appear to a court appearance in a previous issue, that is deemed to go in favor of them being a flight risk. The other thing is, do you have any failure to stop for blue light charges on your record where you didn't pull over for police officers? Do you have any charges like absconding your supervision if you've been on probation or parole? Those sorts of things are going to be, resisting arrest is another one. Something that shows that the person is trying to get away and evade law enforcement. So that's one thing that the judge will consider. The thing that I find amusing is they also are supposed to consider the ties that that individual has to their community. Do they have a job? Do they have a family that is rooting them? What is keeping them in this community so that they are more apt to stay around and answer to the court date for their charge? And, you know, I really have challenged judges in our circuit, out of town and resident and at large seats. I think that they should be saying, number one, and particularly for my individuals that I represent, I only represent poor people. And to be my client, this is how I put it. You know how when you have yacht clubs, for example, they have this like application process and they vet you and they make sure that you are good enough to be in their yacht club. Well, I run a yacht club for poor people. That's what I do. And if you do not meet the federal poverty guidelines, which is not, you know, I mean, it's really low. If you don't meet the federal poverty guidelines, you get the hell out of my yacht club, because you can go and afford to pay an attorney. I am here for those to make sure that the poor people, the indigent people who are struggling, that's a huge population, that they deserve quality and competent representation as well. And what I will say is, I've tried a lot of cases in my career, and I love trying cases. I love being a trial lawyer. It's an adrenaline rush, but I'm never going to try a case to my client's detriment. Sometimes my job is unfortunately to save the client from him or herself because they are emotionally charged in their situation, and that's why you have a lawyer, to help you make a level-headed decision. But I think that judges should ask more things like, do you have a passport? Do you have a driver's license? Do you have a car? Do you know how to get to 26? Do you know where Columbia, South Carolina is? Have you ever been there? Have you ever taken a vacation out of this state? Oftentimes, my clients will answer no to that because they don't have the means of luxuries of cars and things of that nature. That costs money. The second factor that a judge is going to consider is, are you a threat to the victim specifically? So in other words, that means if the judge allows you to get out on bond, are you going to go and threaten, coerce, intimidate, or kill the witness against you to avoid them from coming to court and testifying against you? I'll tell you something. I have a lot of clients that have never been charged with a violent crime, maybe petty shoplifting cases and so on, and this still is an issue with judges determining if they are going to be a threat to the victim, who is oftentimes like Walmart or something, and Walmart will put them on a no trespass notice. The third factor a judge is going to consider is, are you a threat to your community in general? This is where this hot topic is going on right now, and Republicans are freaking out because they want to consider the individual's prior criminal history, okay, where they've already paid a debt to society, but yet that's still held against them. And they also look at, are you out on bond already for other pending charges? Are you out there being a domestic terrorist, terrorizing our community? And the thing that we have forgotten about is we have a huge backlog in the criminal docket in this state, obviously due to COVID. I was actually the first lawyer to try a case in COVID, and Rock Wise was there. He is a member of SCACDL, South Carolina Association of Criminal Defense Lawyers. He is our 8th Circuit representative. I am a member, and I'm also a member, as is Rock, of the National Association of Criminal Defense Lawyers. I think we have 4,000 or 6,000 members in that one. But the thing is that here's a story I want to leave you with, and then I'll take questions because I know I'm running low on time. And no offense, Rock, but you're going to be my example. In 2013, I represented a co-defendant to Rock's client. He was the principal. Rock and Charles Gross were retained to represent this man charged with murdering a 19-year-old SLED agent's daughter in Lawrence County. Now, this was a very hot case in the media. It generated a lot of publicity, and actually, it ultimately ended up making case law in the order of opening and closing arguments that we have in this state between prosecutors and defense attorneys in general. Rock's client was accused of the murder. His bond was set at $150,000 surety, meaning he had to post anywhere from 4% or 10%, and I don't remember this, but they may have given Rock's client a 10% option, which means the family has means enough to put up 10% of the total $150,000 bond. They can post it with the court, and then once that case has been disposed of, the family could get that money back. Okay, that is not an option for my clients who are too poor to come up with that kind of money, so they have to go through a bail bondsman and pay these ridiculous interest rates. And I'll tell you from personal experience that these bondsmen are never held accountable, never. The only time I ever see a bondsman show up in court is when a client has missed a payment or two. And then they're there trying to revoke the bond for violation of bond terms, even though they may have been abiding by everything else. So we have a financial debtor's prison in this country, despite the fact that we are not supposed to. And that's very disturbing. Everyone should be worried about that. My client, not the co-defendant, on a different case, was charged with shoplifting a case of beer from a convenience store. He was a misdemeanor man, okay? Not a felon, but he had so many of these petty crimes, these petty shoplifting cases on his record as convictions, and the judge can use convictions against you, that the magistrate, non-lawyer, set his bond at $25,000 surety for a case of beer, based on the fact that he has been a repeat offender of petty shoplifting charges. Now, because he had so many on his record, it's an enhanceable offense. So that 0 to 30-day misdemeanor shoplifting charge now turned into a 0 to 10-year felony for a case of beer. My client could not afford to bond out on a $25,000 surety. Rock's client afforded to bond out on that $150,000 surety on a murder charge. The prosecutor's offer was ridiculous. They wanted 4 or 5 years out of this guy for a case of beer. This has happened also to my clients who steal things like meat from Walmart to feed their families, diapers, baby formula, things of that nature. And I'm not trying to excuse that, but it should be mitigated because of means. And so my client, I brought the offer to him. I took him up for 2 bond reduction hearings. I was denied both times. The judge found it to be reasonable. I thought that was disgusting. My point is this. My guy didn't want to take the prison offer. So he said, well, I'm just going to sit and wait and get some time. You know, my family's right around the corner, so it's easier for them to visit me at jail. And let me tell you, jail visits with family members are everything to these men and women incarcerated. Keeps their head up. And my guy sat in jail for a case of beer for an entire year. Now, I want to tell you a couple of things. South Carolina's total and per inmate in South Carolina in fiscal year 2018, which is the last information that I could find, SCDC expended $427 million in state appropriated funds for a per inmate cost of $21,756 per year, which is $59.61 per day. I would have just paid the damn case of beer costs, right, under $20, and we could have saved all of those taxpayer dollars from having to keep that man incarcerated, which also caused him to lose his job, which caused his family to be evicted out of their home. You see how this cycle of poverty is perpetuated by the judicial branch of government. The total U.S. government expenses on public prisons and jails is $80.7 billion as of May 25th, 2023. And we have private prisons and jails in this state, which is disgusting in its own because nobody should be making a profit on housing human beings in cages. Those private jails, the United States government spent $3.9 billion. Solitary confinement. Solitary confinement is not only psychologically torturous, but a year in solitary averages $75,000 per prisoner. That's more than some of my public defenders make in a year. That is about 3 times the average annual cost of incarceration in the U.S. and 8 times the average annual cost of public university tuition. I'm going to leave you with this. We call it South Carolina Department of quote-unquote corrections. I want everybody to realize my office does not defend crimes, we defend people. And we have gotten away as a society from the corrections part of that term. We need to be more invested in mental health issues, in addiction issues, in rehabilitative services that are scarce in our jails and our prisons. Because one day, these people, the majority of them, are going to be returned to our community. They could live next to you, your daughter, your son, you and your wife, your kids. How do you want them to return? Do you want them to return worse than when they went in because they got no therapeutic and rehabilitative services? It's strictly a punitive system now. They're going to come out worse. And then they're going to be a felon. And so they're going to not be able to get a good job. They cannot rise above the poverty. And so I ask you all to be advocates for the marginalized and the voiceless in this society. Thank you. Thank you. If anybody has questions, yes, sir.
Well, first, I want to know, how did you get a standing O? I don't know that we've ever had a speaker get a standing O before. I am in awe. Thank you. First question goes to Jamel here.
Thank you so much, Chelsea, for coming. And I'm going to try to combine this question.
Yes, ma'am.
But in a country and in a state where property has always been valued more than people, you can read your history books and find that, right? How do you propose we work to reduce the recidivism rate when your last statement just shows that we're not working to reduce that rate, we're working against that? What are some things that you would propose that we could potentially implement?
Personally, my opinion and my experience with this matter is the majority of folks that are, repetitive clients of mine, frequent flyers, as sometimes I call them, they have mental health issues and they don't have family support. And unfortunately, we have a problem where babies are having babies, and so they're not getting good parental support, and they don't know how to be a parent. I think it does start within the home. But personally, I also think people with mental health issues do not need to be in jails or prisons. They need to build, in my opinion, facilities where there's doctors and licensed professional counselors and social workers, a team of treatment for, interdisciplinary stuff. And I think that the inmates that are having more mental health issues, what's happening to them in the jails, because the jails do not provide an adequate access to health care or medication. So I oftentimes have schizophrenic clients or bipolar clients, or some of them are a dual diagnosis with addiction on top of that because they've been self-medicating. I think that if we were to build facilities that could house those mentally ill, and obviously there would be a screening process, they need to be diverted to those places, a therapeutic approach. We need to be more compassionate as a society and stop outcasting people and leaving them to rot in jails, especially in this state where we are the only state in the country that does not have attorney-conducted voir dire for juries. We have been recently the only state where we have a solicitor control of the criminal docket. And I don't care what Justice Beatty is saying these days, because I've been to numerous meetings that he has summoned me to, but it's still like that in our community, in the 8th Circuit. The prosecutors have the chance to pick the cases they put on the trial docket with very little input from the defense bar. They currently, I think, hold 20% of the cases that go on there. So what I'm saying is, you have people languishing in jail, and we are supposed to have trial dockets, and these trial dockets fall apart oftentimes because prosecutors are not turning over the evidence to the defense to defend these people adequately. So psychiatric help would definitely be something. Job readiness programs, they do have work keys in SCDC, but if you are deemed a violent offender, which a lot of crimes are violent. I think it's ridiculous. These mandatory minimum drug sentences, for example. It is insane to me that you can get more time for a drug offense than you can for raping or murdering somebody. That is insane. And the answer for the Republican-driven judicial branch of government in this state, specifically Alan Wilson, who ran unopposed last term, by the way, we need to find one lawyer to challenge him, and we need to throw our support behind him. Charlie Condon was a former attorney general, or was he the U.S. attorney? I think attorney general. And he once said, when I was in law school, I'll never forget this, he said, we need to bring back not only the electric chair, which was built in 1912 and is still used today, by the way, we need to have an electric couch so that we can murder more people quickly and more effectively. We need a change in attitude. We need to stop being so scared of people with mental health, and we need to get them better treatment and healthcare access. And, right now, Southern Partners Health Center, based in Tennessee, is who the government contracts with. They are a for-profit agency. They do pardon my language, a shit job. And we need to do better about that. We need to demand more rehabilitative services.
Is there another question?
I would imagine, knowing the rural South, that 99% of your clients are Black or Latino, correct?
In Lawrence County, it's a lot of white, actually.
Oh, okay, good. Well, I was getting at the point, aren't most of these non-educated magistrates white people? I think it's a form of racial prejudice that they use underneath the table to control the poor, to the poor down, to them, they're Black, green, or yellow. They use this system, as you're saying, to control these people, to keep them in jail. A lot of them make them, and disgusting.
Well, one thing I do believe, and I've seen this personally, is that white defendants have been treated differently than Blacks. And in my opinion, I am like a conspiracy theorist on some of these, admittedly, but I do feel that part of that is to keep the voting population down in the Black community because they're made felons. And it's amazing to me that our current solicitor, he grew up in private schools. All 90 of his children go to private schools. He's not invested in public school system. And we have a huge school to prison pipeline issue as well.
Next question, please, Phil.
I haven't heard you use the term restorative justice, and I think it's an important concept. But I don't know if that term is a trigger for folks. But the idea of restorative justice, which is a lot of what you've described, just seems like such an important idea. And I wondered if there is any public movement or awareness in South Carolina of the idea of restorative justice, and if there is any organization or organized means of promoting social restorative justice in the state.
There are within the legal community a lot of, I think so there's 16 of my position in the state, 16 circuit defenders, and we are actually all Democrat, I believe, except for one who I, personally don't think he needs to be where he is. But yeah, there are movements, SCACTL, South Carolina Association of Criminal Defense Lawyers, and NACTL. Those are two great organizations to support. There's also the death penalty movement, which has many organizations around the country, the Innocence Project, things like that. They do work very hard and try to legislate. It's just that we are in such a red state right now. And again, I do think that we can flip this state blue. I really do. But I do think it has a primary empowering voting rights, which is what she talked about earlier, but also transportation issues. That's a huge one that needs to be addressed.
We are running very short on time. I got time for two more questions. First Cynthia and then Tori.
So I've heard rumors that through the criminal justice system, if you have money, you're going to be sentenced to home arrest because there's a daily charge for that. However, people who are perceived to not have the means to do that are going to be incarcerated. Can you speak to that?
Yes, I can, and I'll make it quick. That is correct. Home incarceration does cost. Probation costs a lot of money. I tell my clients, probation's awesome because it keeps your butt out of SCDC, but also it's highly expensive. You're put on a monthly payment plan. If you are, and this makes me upset, to be qualified for a public defender, you have to fill out a $40 non-refundable application fee to the clerk of court. First of all, I think that's crap. Secondly, if you are my client, you're represented by a public defender, and you receive a probationary sentence, you are automatically tacked on another $500 to the public defender fund, which the judge has no discretion in because it's set by statute. There's also the GPS monitoring program, and that costs about $380 a month. So if you cannot afford all of these things, then like I said, we have debtors' prisons in this state and in this country, and that's where you'll do your time.
I also want to call out, Cynthia, would you mind standing up? Because she has the best shirt of any of y'all. I may want to borrow that. Can I take that on my trip, please? All right, last question goes to Tori.
I don't know if a lot of people realize in this state, once you have a felony, you lose your ability to vote.
Yes, and there are lawyers out there that try to restore voting rights. There's programs. There's a great organization out of Charleston that I have been working with to restore the rights to vote. Now we have the ability to get people off the sex offender registry if they have, been so many years without any issues, any infractions. But yes.
All right, I'll call a privilege for one final question. You had mentioned that you were an elected position.
That's correct.
But you don't appear on a ballot. So how were you elected to that role?
So briefly to explain this complex situation, all right, so the solicitor is elected by popular vote. I am not. What happens with my position in every circuit defender is there are seats in each of our 46 counties, and it's based on population. So Greenwood has 2 seats, Newberry has 2 seats, Lawrence has 2 seats, and Abbeville has 1. And to be on the selection committee, have one of these seats. So it's a board in the 8th Circuit, it's made up of 7 lawyers. And to qualify for it, Rock Wise is actually on the selection committee. You have to be an actively practicing attorney, and you have to reside in the county that you're trying to get on the committee for. And then I would submit, and all these other people submit, lengthy applications. It goes to South Carolina Indigent Defense down in Columbia, which is our hub, and then they disperse the application. They screen you. If you're not qualified, you don't get your application put through, like if you're barred in another state, not South Carolina. And then they put it to the committee. The committee then conducts interviews that last about an hour each, and then they vote.
Okay. And then the final thing is, when will you be announcing your run against Alan Wilson, and how do we support your campaign? Am I right?
I am extremely anti-death penalty, and that's not a hot issue I'm so thrilled to be amongst like-minded individuals in this room because
Tell me about it.
I'm always fighting, the good fight. But honestly, my dream would be to be a U.S. Senator, and I would absolutely love.
We thoroughly enjoyed you. Can we give her another hand? I thoroughly enjoyed you.
Thank you, sir.
Thoroughly.
Thank you for having me. I appreciate it.
Chelsea, it's amazing how the former president could go to jail and still run for president, but the folk in jail can't vote for the president.
I agree.
Preach. All right, thank you, Chelsea. That was absolutely astounding.